Hi, I'm Marissa Gunn, and I'm a staff attorney in the Family Permanency Project here at the Children's Law Center. I'm going to be giving a presentation about adoption proceedings in the D.C. Superior Court. Adoption proceedings take place in the Domestic Relations Branch in D.C., and there's one adoptions calendar for the entire court. Currently, the judge presiding over the adoptions calendar is Judge Carol Dalton. For adoptions petitions filed regarding children that are involved in the abuse and neglect system, the adoption judge will automatically consolidate the adoption case and the neglect case before the neglect judge so that both proceedings can take place in the same court. One of the key components about adoption proceedings are that an adoption will terminate the parental rights and create a new birth parent-child relationship between the child and the adoptive parent. Birth parents can withhold their consent for an adoption. However, the court can also waive a parent's consent and grant the adoption anyway. In adoption proceedings, it's important to keep in mind that biological parents have a fundamental right to the care and custody of their children. That's why the petitioner's burden of proof is a little bit higher than it is in other civil proceedings. The petitioner in adoption matters will need to prove by clear and convincing evidence that the adoption will be in the best interest of the child. Adoptions in the District of Columbia are governed by a specific code section as well as a number of court rules. The adoption statute provides for who is allowed to file for adoption in D.C. Any petitioner who is a legal resident of the District of Columbia or who has lived in the District of Columbia for at least 1 year prior to the filing of a petition, or if the child is a committed ward of the District of Columbia, meaning that the child is in foster care. Any adult in the District of Columbia can file for adoption. If a person is married, then their spouse must join in the adoption petition. In addition, 2 individuals may file for adoption jointly, even if they're not married. The adoption statute also provides that anyone in the District of Columbia, whether they're an adult or a child, may be adopted. However, if the child is over the age of 14, they must consent to the adoption. For persons under 18, the court can waive their consent if they find that it's in the child's best interests. This next slide covers all of these steps in an adoption case, and I will address each of these steps individually in the rest of this presentation. Adoption proceedings can take place in a 1-step or a 2-step process. In the 1-step process, the termination of parental rights and the creation of a new parent-child relationship occur at the same time. In the 2-step process, the termination of parental rights happens first, and the creation of a new parent-child relationship happens next. An adoption will take place in the 2-step process in the event that someone has filed to terminate parental rights prior to the filing of an adoption petition. In such cases, if the TPR matter has not been resolved prior to the filing of the adoption petition, if the adoption petition is filed while a termination of parental rights is pending, then the 2 proceedings will often be consolidated and resolved at the same time. Parties to an adoption proceeding will include the petitioners, the biological parents, the child, and the mayor of the District of Columbia if the child is a ward of the state. There is no constitutional right to counsel in adoption proceedings. However, where the child is a ward of the state and the cases are consolidated, the parents will often already have counsel, and those attorneys will also represent the parents in the adoption proceedings. Under the one family, one judge rule, adoption proceedings and neglect proceedings involving the same child will both be heard before the same judge. A separate adoption petition must be filed for each child, even if there are 2 children that are siblings being adopted by the same family. The adoption statute and adoption rules provide what information must be contained in each and every adoption petition. Adoption petitioners will have the option to change the child's name. Sample adoption petitions are available on the D.C. Superior Court website. Once your adoption petition is drafted, you'll need to file it at the Central Intake Center at the D.C. Superior Court. For each individual petition, you'll need to provide 1 original and 2 copies. Also, remember to include a copies to page that includes the name and addresses of the petitioner's counsel, the social worker, and all of the attorneys of record that are parties to the neglect matter. At the time of filing, the clerk will assign the adoption petition an A number or an adoption number. The adoption petitioner will not be responsible for serving the adoption petitions. Service is completed by the Child and Family Services Agency's Diligent Search Unit. It's important to remember not to serve a copy of the adoption petition to the birth parents. Upon the filing of your adoption petition, there are a number of orders that the adoption court will automatically issue. The first order is an order of reference for expedited response, for consolidation, and for service. This order is going to direct the Child and Family Services Agency to begin investigating the adoption matter, to draft a report, and to make a recommendation to the court as to whether or not the adoption should be granted. This order will also consolidate the adoption case and the neglect case before the neglect judge. The next order is a notice of adoption proceeding and order for show cause. This order is provided to anyone whose consent is required for the adoption, so it typically goes to the birth parents. The order will usually include the first court date, or the initial show cause hearing, and it must be served personally on the birth parents. Again, the Diligent Search Unit at the Child and Family Services Agency will be responsible for serving this order on the biological parents. In the event that the Diligent Search Unit is unable to personally serve a birth parent, the court may grant a motion for constructive service. The first hearing after an adoption petition has been filed is usually the initial show cause hearing. Typically, this is a status hearing at which the court will inquire about the status of service on the birth parents and about whether or not the birth parents intend to consent to the adoption. If at the time of the initial show cause hearing, it's apparent that the birth parents will not be served personally, you might consider asking the court to grant a motion for constructive service. The next step in the adoption process will be a contested show cause hearing. The contested show cause hearing is essentially an adoption trial. This is where the adoption petitioners will be required to show that the child is physically, mentally, and otherwise suitable for adoption, that the petitioner is fit and able to give the child a proper home and education, that the adoption will be in the best interest of the child, and that the birth parents either consent or there's a reason why the court should waive the birth parents' consent. One of the most important elements in proving your adoption case is proving that the adoption petition is in the best interest of the child. There is no guidance in the adoption statute about what it means to prove that adoption is in the best interest of the child. However, you can use the factors outlined in the statute for the termination of parental rights as a guidepost. Leading up to your adoption trial, there are a number of things that you can do to build your case. That includes attending the neglect hearings, getting a full copy of the neglect file, making a timeline, talking to the social workers, the GALs, and other parties, making sure that you visit your client's home, running background checks on the parties and any other relevant people, and requesting the CFSA file. You should also begin identifying and preparing any witnesses that you may wish to call, and generally preparing yourself and your case for trial. In adoption proceedings, discovery is only permitted when the case is contested. In the event that you do have a contested adoption proceeding, it's advisable to request the court to order formal discovery and to set discovery dates. In adoption cases, unlike other family court proceedings, you must get court approval before serving any subpoenas for documents or witnesses. It's also a good idea to circulate a pretrial statement among all of the parties to an adoption case. This statement should be filed with the court prior to the trial, and it will help focus the trial and reduce the likelihood of unfair surprise on the date of trial. Something that you might consider discussing with your clients is a post-adoption contact agreement, or a PAC agreement. Post-adoption contact agreements govern contact between birth families and children after an adoption has been granted. It's up to the adoptive parent as to whether or not they wish to enter into a PAC agreement. And once a PAC agreement has been entered into, it may be enforced or modified by the family court by anyone who is a party to the agreement. Before the court will grant a modification, it must determine that the requested modification is in the child's best interests. PAC agreements can have significant consequences for your clients, so make sure that you discuss them thoroughly before you have your client agree to a PAC agreement. Once your adoption trial is complete, the court will issue a written findings of fact, conclusions of law, and order waiving the birth parents' consent if their consent was not provided. However, your adoption will not be finalized until the court issues a final decree of adoption. The court will not issue its final decree of adoption until it receives a completed report and recommendation from the Child and Family Services Agency. The court will often leave it up to the adoption petitioners as to whether or not the issuance of the final decree happens in chambers or during a ceremony that will be held in the courtroom. The adoption petitioners choose to have a final decree ceremony. The court will often bring all of the parties into the ceremony and will provide snacks and other toys for the child as appropriate. The court will issue 4 certified copies of the final decree of adoption to the adoption petitioner's attorney, and upon request and payment, with the final decree of adoption, the petitioner may obtain a new birth certificate at the Vital Records Division. Once a final decree of adoption has been entered, there is the possibility that opposing counsel will file an appeal. If the matter was heard before an associate judge, opposing counsel will have 30 days during which to file their notice of appeal. If the matter was heard before a magistrate judge, they will only have 10 days to file their notice of appeal. Thank you for taking adoption cases from the Children's Law Center. We hope that you find the experience as rewarding as we do, and you can always contact the Children's Law Center for additional guidance or support.